Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Welcome to St. Louis on the Air. I'm Jeremy Goodwin. Today we convene this month's Legal Roundtable, where we delve into some of the latest regional and national news stories pertaining to the law. As always, there is a lot to discuss, and joining me in studio today to do just that, we have Bill Freivogel. He's professor for the School of Journalism at Southern Illinois University, Carbondale. Mark Smith, associate vice chancellor and dean for career services at Washington University. And we welcome Jacqueline Kutnick-Bowder, managing attorney for civil rights and systemic litigation at Arch City Defenders. Bill, Mark, and Jacqueline, welcome to the program.
Thank you so much for having us.
Well, before we dive into this, we do want to mention to our listeners, we are recording this conversation on Wednesday afternoon as former special counsel Robert Mueller testifies before Congress. We figured we're going to let NPR's day-long coverage of that testimony on Wednesday stand on its own for now, and we'll keep the focus on some other issues that have not been getting round-the-clock coverage this week. We will, of course, keep talking about Mueller and his testimony on future episodes of the show, though. But for now, let's take a look at the Supreme Court. Its 2018-2019 term just ended. This gives us a lot of material to look at. As always, there was a lot of news there, including a lot of correspondence, we'll say, between the White House and the court, and we'll talk about that in a few moments. But in terms of legal precedent, I'm wondering, are there particular rulings in this term that anyone would point to as some of the more significant ones? Mark?
Yeah, so I'm happy to start. So one of the cases I thought was interesting, I don't know that it's the most important decision, but I just thought it was interesting, was this American Legion case. The case involves a 40-foot cross, Christian cross, that's erected in suburban Washington, D.C. It's been there since World War I, right after World War I, and it was a monument to the fallen in World War I. And it was recently challenged by some citizens saying, this is on government land, so this is an endorsement by the government of the Christian religion, and we need to take it down. And so the Supreme Court, they lost at district, or they won at district court. They lost at the Court of Appeals. The Court of Appeals saying you should have to take the cross down. Okay. The state lost, and then and the American Legion, and then the Supreme Court said no, you can keep it up. And basically, there's been this test called the Lemon test, based on this case with the word lemon in it, and which is not a great legal precedent, and the courts have kind of complained about it, and so I think some people were thinking, well, they might overturn the Lemon case and come up with a new rule.
Yeah, this doesn't seem to be like a new dispute, right? The idea of
it's been
the
coming
religious
up.
symbol on public grounds.
But the issue just came up,
Yeah.
and that was actually an interesting issue, which you identified, because Clarence Thomas spent a lot of his decision talking about standing and whether or not you could even, had standing because it had been there so long.
To challenge its presence.
But basically, the way I read it, kind of in layman's terms, what the Supreme Court seemed to be saying is, if you have something like this and it's been up for a long time, we're going to let things slide. And we're going to say that there's a secular purpose and that's enough. But one of the factors they were really looking at, the fact, which you just identified, that it had been up there for, almost 100 years. And so we're not going to say it's a government sanctioned endorsement of religion. But
so there's a difference between allowing something to remain in place and putting something new.
Yeah, I think if you tried to do that right now, you wouldn't. But what I found interesting about it was that they did not overturn the Lemon case, which I think there was a lot of discussion this term about stare decisis, which is this idea that we should defer to previous decisions. And I think Roberts is very big on not making it look like they're overturning previous decisions. And I think that may have been part of it. I think also this case, as I recall, had 9 separate opinions. I think I'm right about that. But you had a plurality, but not a real clear rule of law, which I think is another thing. We've got 2 new justices. Kennedy, who was the swing justice, is gone, and so things are very much in flux.
And I think something that folks are looking at in this newly constituted court is exactly how they're going to deal with precedent, particularly precedents that are maybe only a decade or two old.
Like the Roe.
Like, for instance, Roe v. Wade.
Except Roe v. Wade is 50 years old. So,
okay.
So it's not like just a...
it's not a new thing.
It's not that different than the church-state decisions was come out of the 60s. So in this Cross case, I mean, the result is pretty much the same as things have come out in recent court terms. It's something that's historical and been there for a long time, sort of gets grandfathered in. But you can't be the Chief Justice of the Alabama Supreme Court and require to have the Ten Commandments in the courthouse, or a judge can't nail up the Ten Commandments on his wall. But you can have, the court said before, Texas state grounds could have a monument to the Ten Commandments. I think this court will definitely be more in favor of approving religious observances and religious references to religion. Kennedy was pretty much Kennedy, for example, was the key vote in deciding that a graduation student prayer violated the Establishment Clause. So replacing Kennedy by Kavanaugh makes the court more of a pro-religion court.
Mm-hmm. Well, it was a busy term. Was there another thing that came up this year that seems to you, Bill, is particularly significant?
Yeah, well, I mean, it wasn't like there weren't blockbuster decisions. A really important decision, which was not that, I guess, surprising in the end, was the Supreme Court saying that they were not going to constitutionalize the issue of partisan gerrymandering. They said partisan gerrymanders have been around forever. We can't find any kind of judicially manageable standard that we can use to decide when is a gerrymander unconstitutional and when unconstitutionally unfair and when is it not. And so
there's no I know a gerrymander when I see it.
That's right. There's no.
That's like the pornography thing, and some of the commentators have said exactly that. And you don't have that.
Except the lower courts had been developing and using some tests. And another thing that's really interesting about this decision is that the court separated the idea of political gerrymandering from racial gerrymandering and one person, one vote types of gerrymandering. And it seems on some levels to be somewhat of an intellectual distinction. A lot of times if you're talking about gerrymandering because people live in a certain neighborhood, the neighborhoods that we live in are often based on especially in St. Louis, on racial issues. It can also be based sometimes on political issues. People tend to like to live near people that think and act the way that they do. And so even though the court sort of draws this political distinction, I'm not sure in practice if it really is a real distinction. And so I think that the decision in some ways is going to create some confusion in the sense that people may have difficulty or there may be more litigation about is this a political gerrymandering decision or is this a racial gerrymandering decision? So I don't think this is the last we've heard on this.
That sounds extremely sticky.
Yes.
Yeah.
But I do think the court wants to try to draw a bright line and get out of it.
Yes.
Get out of this.
Yes.
They've been for about 20 years. They've been saying, well, there might be some sort of case where, especially Justice Kennedy said, there might be some kind of case where there is an unconstitutional political gerrymander, but we've got to figure out how to determine what that is. Now, basically, the court says we can't. That is not something a court could do. It's a political question. The political branches have got to decide that. And, they sort of the end of the opinion, they sort of are saying, this doesn't mean we think it's a great idea to have political gerrymanders. And look, there's a bunch of legislatures and states that are doing something about it. And Missouri, would be one that, would sort of fit in that category, although we'll see how that works out.
So I think that's the next step is I think there may be what Jacqueline said, this people trying to get it into the racial thing, but then there are also maybe more lawsuits in state court under state constitutions. And then like what happened in Missouri, we had wasn't that Amendment 1? And so
The Clean Missouri.
What? The Clean Missouri
Missouri
one,
mm-hmm.
Right. And so you're going to see probably not coming from legislatures because they're political animals. This is what they do. But I could see statewide initiatives in other places and efforts to try and undo this. But, I think the same issue the Supreme Court has, it's like what Jacqueline said. People segregate, rural areas are more Republican. Urban areas are more Democratic. So in Missouri, even if you have a percentage, it's going to be tough to draw districts if 90% of the people in the urban area are all Democrats. We're packing and cracking ourselves by
and
the way
with
we
the
live.
increased tribalism in American
Yeah,
politics,
right.
it's getting harder and harder to draw distinctions between, one's identity is tied into one's politics right now pretty closely in a lot of debates.
Yeah, and I mean, and let's make clear, Republicans and Democrats alike do this.
Yeah.
Yes.
In Illinois, the Democrats gerrymander. In Maryland, one of the cases before the Supreme Court, it was the Democrats. A case a year or two ago from Wisconsin was the Republicans. Generally, the Republicans have been more successful, I would say, over the whole map of the United States in having political gerrymanders that help them have more representatives. Like in the Wisconsin case, they had their gerrymander was set up in such a way that even if Republicans got far less than 50% of the votes, they still could win a supermajority in the legislature.
Yeah.
And I feel a little remiss if I don't mention that, of course, the term gerrymandering is a contribution to the lexicon by a political cartoonist with respect to the household name Elbridge Gerry, the Massachusetts governor and former vice president, and the idea that these congressional districts or districts for any legislature are constructed in such a strangely shaped way that it looks like a salamander. I don't know what a salamander looks like.
I'm not an expert on that.
I'm not either.
But we are supposed to have compact districts, and a salamander is not compact.
Okay, and that's written into the law?
I do know that. Yeah, the compact. I think that's one of the
Compactness is one of the
criteria.
Yeah. Doesn't always work out that way, though.
Yeah, right.
Well, we do need to take a quick break, so we'll do that. But we will be back shortly to continue this conversation. This is St. Louis on the air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
And welcome back to our discussion on some of the latest regional and national news stories, all having to do with the law. One overall observation about the last two Supreme Court terms is that the Trump administration seems to spend a lot of time arguing before the court compared to other administrations. Is that a fair observation?
I think so.
Bill?
I think probably so. Yes.
Jacqueline? Yeah.
I mean, they asked for a lot of emergency actions by the Supreme Court, either to speed up some sort of appeal or to delay something. And so, yes, there's been a lot of sort of extraordinary writs that they have filed before the Supreme Court.
And on that point specifically, there's a thing called an emergency application, which we've heard a lot about lately. What's that?
Well, I mean, that's in the kind of situation where, let's say, a lower court judge issues an injunction, which means an order to stop something. Let's say a lower court judge issues a nationwide injunction stopping the enforcement of some Trump administration policy change, whether it be on immigration or health care or whatever. And then the Trump administration doesn't want that court order to go into effect, so they go to the Supreme Court and say, please, stay this. In other words, delay the enforcement of this injunction until the case makes its way through the Supreme Court. That'd be an example.
And the word emergency is not really a term of art there, right? I mean, these are time-sensitive requests that are for extraordinary situations.
Yeah.
Okay. And they used to be kind of rare, right? And Washington Post columnist Linda Greenhouse took a look at an upcoming article in the Harvard Law Review to crunch some of the numbers on this. And she came up with these numbers. The George W. Bush administration filed these emergency applications 6 times in the 8 years. President Obama made these emergency requests 4 times in his 8 years. If anyone doesn't happen to know the number offhand, would you like to take a gander at how many the Trump administration has filed?
Around 30?
Yeah, 28.
Wow.
28 and counting, I suppose. What does that tell you about just the relationship between branches of government right now? Jacqueline, any thoughts?
Well, I think that that one of the things that we're seeing is that the courts are curbing some of the decisions that are being made by the executive branch, and that rather than going through the normal process, the normal appellate process, that this administration is choosing to request that these be heard in an emergency way. And I think that it's a response on some levels to the fact that they are losing consistently at the lower court level, and there's a sense of not trusting the legal process to resolve the issue, or at least that's my take on it.
And perhaps a sense in the Justice Department that the current Supreme Court might be more friendly to their argument, basically.
I think that may be true for some people in the Department of Justice. I mean, I think we need to distinguish between the Department of Justice political appointees and the Department of Justice employees and lawyers that are career lawyers and that represent the government across various different administrations.
But I would say there's definitely a tension between the Supreme Court, particularly Chief Justice Roberts, and this effort by the Trump administration to get the Supreme Court to be friendly to them, and that sort of showed up in the census case, which is another important one that was decided this year. I think I don't think that Trump, the Chief Justice has made pretty darn clear that he doesn't like the way the president talks about Obama judges, and implying that anybody appointed by Obama is going to rule against him.
How has Chief Justice Roberts expressed an opinion on that?
Well, he actually made a speech about it.
Yeah.
But he ruled against the Trump administration on the census, where it looked like, it appeared after the oral argument in that case as though the administration, this is the question about could there be a citizenship question added to the census, as the Trump administration wanted to do. And after oral argument back in the spring, it looked as though the Trump administration was going to win very easily. Everybody seemed to sort of be on their side.
That's the sort of day of analysis of the actual arguments.
The day of analysis, right. All the conservatives seemed to be on board. And then, some information started coming out, some political operative died, and in his papers it was clear that the reasons given by the Trump administration for putting that question on the census were trumped up, and so in the end, the Chief Justice went over to the other side and said, even though the president's got and the administration has broad authority here, and there have been citizenship questions on past censuses, they got to at least come up with some sort of believable reason. And this one about it being to help with enforcement of the Voting Rights Act doesn't pass muster.
So basically, the court asked the White House to provide a good reason for why it wanted to add this question, are you a United States citizen, to the census, long after the form was supposedly completed and ready to start to be printed. Yeah. And what was the response from the White House to help enforce the Voting Rights Act?
Yeah, that was their court, what they offered in court as their reason for putting that census question on was to help with enforcement of the Voting Rights Act. But I think, as the court pointed out, they came up with that rationale long after the political appointees already had decided they wanted to add the question. So it was like a post hoc rationalization, and not really a reason for doing it.
I think, if I can jump in, just to give some context to that, what they were saying, or what the government was saying, is that the Department of Justice requested this information.
Yeah.
Okay. But what happened is, with this information that came out, it became clear that actually that the secretary had been attempting to get different departments in the government to say that they needed the citizenship question. And he
So he was
ultimately
sort of canvassing and saying,
yes.
come on,
Ask me
folks,
this
one of you
question,
must
right?
want this
Yeah.
question, right?
Exactly. And then he got the Department of Justice to bite. And so what happened is Roberts, in going back to what Bill said, you could see this as a bit of a rebuke if you wanted to, and that is that Justice Roberts basically says there's evidence this thing is completely pretextual here. And that is a pretty strong pushback in a lot of ways.
Yeah, the Supreme Court doesn't say things like, you lied to me, right? But in this case, in this case, it did say that the explanation that Commerce Secretary Wilbur Ross provided was, I'm going to quote, incongruent with what the record reveals.
And that's as close as you get to a lie from the Supreme Court.
And also that the evidence that they took a look at, quote, reveals a significant mismatch between the decision the Secretary made and the rationale he provided. So in the context of this sort of rarefied air of the Supreme Court talking to the White House, are those fighting words, Mark?
I don't know that they're fighting words, but I mean, I do think this is a pretty extraordinary, because under the Administrative Procedure Act, the courts give a great deal of deference to administrative agencies. And here they're basically saying what you did was arbitrary and capricious, which is a really tough standard to meet. And it's a nice way of saying, yeah, liar, liar, pants on fire. I think.
And I think something else that makes it even more interesting is that Roberts says, well, it may not really be arbitrary and capricious, but it's pretextual, which is sort of this new.
What does that mean? Pretextual.
It's made up.
Yeah,
Basically,
it's lying. Right?
Lying. It's a fancy legal word for that. But basically, he sort of creates almost this additional part to this test, which I think now you may see. Bright lawyers obviously are going to sort of glob onto that and say, okay, so now I can talk in terms of pretext. That what the government is saying is just not true. And that's now something the Supreme Court has stated is a legitimate argument to try and go after the government with.
And I do think what you said before and what Bill kind of alluded to with Roberts, I mean, he believes in the integrity and the reputation of the court. And Trump is out there attacking the court, saying these judges, they're Republican or the Democratic, and they're not fair, basically. And so he's attacking this institution. And while I think they might be inclined to support a lot of stuff, they don't want to encourage that kind of behavior. This what Trump is doing is going outside of what have been norms that have been followed by other people, and I think that's upsetting to a lot of people. And particularly Roberts.
And we see that in the relationship between the executive branch and the court as well.
I think so. Yeah, I think that's part of it. It's not the whole thing.
I mean, at first, Trump's reaction to Roberts' decision was to basically say he was going to put the question on anyway.
Yeah.
Sort of the president, which could have set up a constitutional crisis of the president not following what the Supreme Court says. Then he also took the fairly extraordinary steps of the Justice Department removed the line, the professional lawyers who had been handling the case on behalf of the government, so they could put in some people who would, make their arguments for why the question should be added.
Before we move on, let's talk about that last twist in this. You could make a movie out of just this dispute, right? But after the court gave its final ruling and the Justice Department acknowledged publicly that this thing is over, a few hours later or the next day, there was a sudden 360, right? Because the president sent a tweet saying, no, that's not true. We're going to keep doing this anyway, basically.
Right. Then the judge asks the lawyers, what's going on? The lawyers say, we don't know. And then those lawyers are gone.
Yeah, and that transcript is available. They're saying things like, we're learning about this as you are. We don't know any more about it than the tweet.
Right.
Yeah, that's not the position you want to be in as a lawyer. I mean, you don't want your client... I mean, you're supposed to be handling the legal strategy, and then if your client starts saying stuff, you don't want to go up to a judge and say, I don't know, or I'm going to have to change this was not true. That's all.
But this matter is over now? The question will not be on the census, as far as we can tell?
Well, it's not going to be on the form that's printed out by the Commerce Department, but I think the president said they were going to try to find some additional government information that would give them the answer to how many people are citizens and not citizens, but and there might be maybe some additional forms sent to some people to answer that question. I don't know about that latter.
Well, since we last met and convened a legal roundtable here, of course, former Supreme Court Justice John Paul Stevens did die. Let's talk a little bit about his legacy on the court. Would anyone care to wrap that up for us?
Well,
Put a bow on a long and storied history.
Yeah, Justice Stevens was really from another era. I mean, another era. He was He was appointed by Gerald Ford. Gerald Ford said he was actually looking for the best legal mind he could find, instead of what presidents often since have been doing, is either trying to find somebody who will uphold Roe versus Wade or vote to throw out Roe versus Wade.
Was he perceived as a liberal judge at the time of his nomination?
He's a Republican judge. He was the appointee of a Republican president. Was considered to be, a very well-respected Chicago lawyer. He turned out to be very independent, and by the end of as years went on, in his, I think, 34 years or so that he was on the bench, he really became. I mean, his results. The result that he would support would tend to be more one that would make liberals happy than conservatives, although not always the case. I mean, one late case that he decided that liberals didn't appreciate was he upheld Indiana's law requiring voter ID, which has then been sort of the basis that Republicans have used in a lot of states to try to hold down the number of people who can vote. So he was criticized on that. Eventually, I think, said he regretted that decision. He apparently, Linda Greenhouse had an interesting, the New York Times reporter you talked about before, who used to cover the Supreme Court. Linda Greenhouse had an interesting remembrance of the day that the Supreme Court announced the Citizens United case. That's the one that says corporations can make unlimited contributions to support the election of a candidate, and Justice Stevens strongly dissented. Justice Stevens says, why should they be able to do that when they can't run for office? I mean, corporations can't run for office. Why are we giving them the same kind of rights for political contributions? Apparently he felt so strongly about this. He was reading his dissent from the bench, as justices do when they're really mad about when they think it's an important case and they disagree, or when they're reading the opinion for the court. And he was stumbling over his words, and maybe because he was so emotional, maybe because he was 90 years old, and he thought, well, it's time to go. The other case,
that dissent also, I believe, included that memorable phrase that American democracy is imperfect, but no one would suggest that one of the problems is a lack of corporate money.
Yeah, right. Another case where he wrote a very long dissent and felt very strongly the court had acted incorrectly was in the Heller case, establishing an individual Second Amendment right to have a weapon to protect yourself in your house. He wrote a long dissent saying, hey, that's not what the Founding Fathers meant by the Second Amendment. So he sort of took on Justice Scalia mano a mano, and
did a historical legal analysis, which was what Scalia does all the time, and kind of
let's read the history right. Stevens said, not the way you just want to make it up. And later, I think Justice Stevens recommended that the Second Amendment be repealed.
Okay, we do need to squeeze in another break here, so we're going to do that. We will be back in just a moment. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Welcome back. It's our legal roundtable today, and I'm talking with legal experts Bill Freivogel, Mark Smith, and Jacqueline Kutnick-Bowder. Thank you so much for joining us. The minutes just fly by because there's so much going on, and it's hard to even pick what we can squeeze into this conversation, but we're trying to cover what we can. So there is an explosive story breaking this week involving a St. Louis man who was convicted of murder in 1995. St. Louis Circuit Attorney Kim Gardner filed a motion Monday for a new trial in the case of one Lamar Allen Johnson. Her office is saying he was wrongfully convicted for a host of reasons, including prosecutorial misconduct. One thing I'm just wondering, how unusual is it for the city prosecutor to file for a new trial in a murder case that it previously prosecuted and won? Do we see that much?
I think that's unprecedented. I don't think we've ever seen that.
At least not in this case. I mean, I think maybe Jennifer Joyce, where new evidence was raised.
That's a good point. Yeah, because she had that Innocence Project working out of her office, right?
She did, but this is sort of I think a sort of a new
Different
take
thing,
on that. This is what is it called? The Conviction Integrity
Conviction
Unit?
Integrity Unit. What's the Conviction Integrity Unit?
So they look at these old cases where there might be a question of wrongful conviction, and it's got outside funding. What's really unusual is for the prosecutor to go to court and say, because of prosecutorial misconduct by our office,
By our own office.
Our own office. This should be thrown out. I mean, I think there's. It seems as though there's pretty strong evidence that identification evidence was sort of obtained by coercive means by the police, and maybe there was an offer to actually compensate somebody for testifying wrongly about this guy being the culprit.
The key eyewitness was paid over $4,200 once he started cooperating with investigators. And a key point in the motion here is that was not disclosed, that in fact defense counsel had requested repeatedly over the years, are there any records about payments? And they were told that no, those records don't exist.
Right, and you have to disclose, exculpatory evidence in a situation like that. I mean,
that's because a jury could easily find that the fact that someone was paid meant that their testimony is not correct, right? And so that's why it's so incredibly important, because it means that the whole underpinning of the trial is in question, because it was based primarily on this eyewitness identification.
So it's not so much that the payment was improper in some way, but that it was kept a secret.
Yeah, it was kept a secret, and the jury couldn't consider that when deciding whether or not this person was speaking truthfully when they identified Mr. Johnson.
Yeah, and this conviction dates back to 1995, but the offenses alleged in this motion are not ancient history. They go up to 2014 because his attorneys had repeatedly requested this info and were told as recently as 2014 that stuff did not exist. Have we seen other cases like this in St. Louis of a wrongful murder conviction that was really cleared up eventually?
I believe that there was another. The name of the defendant isn't coming to my mind, but as I recall, there definitely have been other Missouri persons who were convicted of murder, some sentenced to death, who were cleared and left and got out of prison. And I think another one may have involved the city of St. Louis, so I cannot remember the name of the person. But it's this case, the way in which Gardner is requesting that Johnson get out of prison. This is a different kind of motion, legal motion than has ever been made before. So we'll see. I mean, they're sort of relying
does the law provide for a new trial 20, 25 years later?
I mean, they're saying that because of exceptional that courts can deal with situations that present exceptional circumstances, and that these are exceptional circumstances. So a fairly broad kind of judicial power. We'll see.
Does the length of time from the conviction to now play into this? Does it make it harder to get to the bottom of something like this? I see some furrowed brows, Jacqueline.
Well, it can. I mean, I think in this case, the gentleman who made the original identification is still alive. But what happens often...
And he's been attempting to recant.
He's been attempting
years.
to recant for several years. But what happens often, the longer the longer the time period, the further you get away from the actual incident, the harder it is to find people, the harder it is for people to remember what happened. There's been a lot of research over the past decade or two about eyewitness testimony and how it becomes unreliable and more unreliable over time. And so I think that, we should be applauding Jennifer Gardner for taking a look at these issues. I'm sorry, did I say Jennifer? Excuse me. For Kim Gardner, for implementing the Conviction Integrity Unit. And I think it's part of what she's attempting to do by sort of changing the approach of the prosecutor's office in the city of St. Louis. So I think this is just one part of her attempt to make the prosecutor's office more, I'm trying to figure out what I'm trying to say, but to make the community more comfortable about some of the decisions that are being made by the prosecutor's office. I think that's a better way of putting it.
I mean, Kim Gardner is one example of a trend that's post-Ferguson trend. The Wesley Bill would be another. Kansas City prosecuting attorney a third. Philadelphia prosecuting attorney it would be a fourth. Of these more defense-friendly prosecutors who are looking at possibility of wrongful convictions or looking at alternative ways, ways to not have people locked up prior to trial for as long a period of time.
Look at more social justice issues rather than just a conviction rate.
What's the Midwest Innocence Project?
I think it's out of Northwestern, isn't it? And they have
I
offices.
I don't think it's connected.
I
I could be
thought
wrong, but I don't think
yeah.
it's connected with the Northwestern Innocence Project. That was a Northwestern Journalism Law School project.
Right.
Midwest Innocence Project, I dealt with them some way. I used to be a reporter. And I think they have mainly been oriented towards the potential innocence of death row inmates, mostly. Or people who are convicted of murders, but I haven't dealt with them in a while. So
I seem to remember when I was at the law school, we would have law students working in Jennifer Joyce's office, and they would go through old cases where they still had forensic evidence and using new techniques, just look for any problems, and they would have law students go over and help with that process. And I thought the Midwest Innocence Project was involved with that with Jennifer's office, but I'm not positive.
Yeah, they may have been. But, I mean, it's true. I think that Jennifer Joyce did have that going on. So it's not like she was blind to the possibility of
but I think
wrongful convictions.
Obviously doing it as well.
Yeah. And I do want to mention that the lawyer who prosecuted the case originally, a man named Dwight Warren, has called this motion nonsense. He was a well-respected assistant circuit attorney from 1977 to 2017. He left that office shortly after Gardner was elected. He's also a veteran of the St. Louis Police Department and a Vietnam veteran. Let's change gears if we can. I'd like to say something to our great crew over in the studio there, over in the control studio. Would you play Gloria? Okay, so when I said play Gloria a few moments ago, I didn't make any money off of that, so I'm safe from the cease and desist letters a Philadelphia bar called Jack's NYB has been sending to vendors who have been using that phrase to sell merchandise. This was originally reported by the Missouri Lawyers Weekly. For those listening now who live in around the city and haven't heard, a handful of St. Louis Blues players were at that bar mid-season when they noticed that Laura Branigan's Gloria, which we just heard a few moments of, would get everybody up and dancing, and the bar patrons would yell, "Play Gloria," and the song became the team's victory song. It went from worst to first over the course of half a season. So the bar in question is claiming a trademark on that phrase, "Play Gloria." Does it have a point?
I don't think it does. And it's, I put myself through law school as a bartender. A bunch of drunks in a bar chanting "Play Gloria" is not first to use rights, for commercial use. It's just a bunch of drunks. And so
we haven't measured their intoxication levels.
Yeah, well,
it is a Philadelphia
listen,
bar. So
I was a bartender for a long time.
Okay.
If you're in a bar, you're drunk. Yeah. And so first of all, I'm not even sure this phrase is trademark protectable. But then, even if it were, and I think that's a big if, because what product are you thinking of? That's what trademarks are supposed to be for, and then it would be first to use, and I don't think, the Blues started using it. They started putting it. I went to my first hockey game in 10 years, saw Brill Freivogel there, and I saw the first time play Gloria stuff there. So that was like in February or something, right? And this is when the bar said they started doing it. So I think the Blues have. And like I said, I don't think they put it on shirts or anything. So I just think this is a nice way for a little corner bar to get a lot of publicity, but I don't think they're going to get anything out of it. I could see a bunch of drunks thinking around, and there's a lawyer there who comes up with this idea. All it costs is a couple of stamps.
Yeah, I agree with Mark. You can't trademark. That bar can't trademark this phrase. It's got to be a trademark. It has to some way identify the goods.
Goods or services, right?
Goods or services of the bar.
Well,
And
for lack of a better word,
that.
how original does an expression have to be to merit protection, trademark protection?
Yeah, that's the other thing. That's why the drug companies are great about this, coming up with trademark names. They just make up, Cialis and all these made-up words, and that's very trademarkable. But just coming up with something like, Mark's Coffee Cups, that's much tougher to trademark because it's not a unique expression. It's just tougher.
Well, what's the difference between, like, say, Play Gloria and Where's the Beef? One of those is very identified with the Wendy's chain, but it's still three simple words that we use in our everyday conversation. It doesn't sound that original off the top of the head. What makes something able to be protected like that?
Golden arches aren't that unique. But it's got to be something that identifies some goods, and this doesn't identify the goods. You could claim the bar could claim that the T-shirt that they did with Play Gloria, the way they designed that T-shirt, that should have copyright protection.
Yeah,
that's another form, a different form of intellectual property from a trademark.
Unique expression of an idea, so that would work.
But that wouldn't keep some the Blues, for example, doing a T-shirt that had a different expression of Play Gloria, a different way of expressing it. So they're not going to get anywhere on copyright either.
And the opportunity cost of a law firm sending out some cease and desist letters.
Pretty low.
Right. Yeah.
And they might get someone to pay
to buy
as well.
Yeah. Or they get free publicity, or they get people to come to their
which
bar.
We're giving them right now.
Yeah, exactly.
Well, if folks in our listening area are looking for somewhere in Philadelphia, I guess they probably consider this a landmark anyway at this point. The Blues fans might want to be trekking there anyway.
No, they don't want to go there because they're trying to keep the Blues. Okay. I think we should be boycotting them.
All right. St. Louis Public Radio isn't calling for a boycott.
Yeah, nor is Mark Smith.
Okay.
Right.
Okay. You're welcome to.
Yeah.
All right. Well, let's turn to another story that we have been following at St. Louis Public Radio and here on the Legal Roundtable. A man named John Rollo. We might call him an aspiring marketing executive, perhaps. The Post-Dispatch refers to him as a Steve Stenger crony. Riverfront Times called him Stenger's fancy friend, which doesn't sound that bad to me. I wouldn't mind being someone's fancy friend. That's okay. Well, in any case, Rollo donated thousands of dollars to Stenger's campaigns for county executive, and in exchange, Stenger and the former head of the St. Louis Economic Development Partnership, Sheila Sweeney, they directed a marketing consulting contract to Mr. Rollo, though he had no relevant experience. And Rollo has admitted to this in court. He pleaded guilty to bribery, mail fraud, and theft of honest services in U.S. District Court. First, just what's theft of honest services? Bill?
Well, it's actually a fairly controversial charge that's used in a lot of these public corruption cases, and there've been some judges. Justice Scalia himself was not a big fan of the charge of theft of honest services. It's a way in which prosecutors, pretty often federal prosecutors, can file public, corruption cases where they say, let's say they've got some sort of email exchange or cross state boundaries telephone exchange that shows somebody's making some sort of corrupt deal, like to get a contract that they don't have any kind of reason other than political support to get, as in this case, and then you can say it's you got wire fraud to steal the public's expectation that their public officials will be honest.
Mm-hmm. Mark, there's some dispute over this charge in this case specifically, or just
I think this is our friend Hal Goldsmith, who's a prosecutor, who you don't ever want to have Hal Goldsmith calling you saying, I want to talk to you about something I'm going to be bringing at you. He's a very good prosecutor, and it sounds like when you read I just read the Stanger indictment. I didn't read the other ones, but it was clear that they had all kinds of emails, text messages. So they have these folks dead to right, which is why I think everyone's pleading to it. And it's just it's a sad situation, I think. Just, these people there was no reason for Stanger to be doing this kind of stuff. And it's just disappointing. And it undermines people's
this wasn't
faith in
cloak and
government.
dagger kind of stuff, right? I mean, this seems like a pretty clear quid pro quo. That reminds me of the big city bosses of 150 years ago or something. Is there a sense that there might be more arrangements like this out there that are waiting to be discovered?
Well, I mean, the Rod Blagojevich case was very much like this.
Mm-hmm.
I think it
Governor
even
of
involved
Illinois.
Governor of Illinois. He's still in prison, I think, isn't he? So I believe there was a theft of expectation of honest services.
I mean,
in that
I would
case
not
as
be
well.
surprised in the Stenger case if it's not over. If there are other people, I mean, once you start digging, and you get somebody's phone records, there may be other potential.
Yeah, and of course we don't know that to be the case.
No.
But given the brazenness of this arrangement, it's fair to ask around.
This was yes, so brazen and so just clear cut.
It was so brazen that I can't be like you. I can't feel sorry for these guys. I mean, they're just stealing from the people, and they should go to jail.
Jacqueline, do you want to add something?
Well, I wanted to say the fact that these pleas have come really, really quickly too. I mean, this is normally you don't see someone charged and then pleading as quickly as we're seeing now, and so I mean, it makes me wonder at least if they're also potentially have more evidence that they can provide to the government, and that might be part of why they're pleading so quickly, is that then they can turn state's evidence, so to speak, and that Hal Goldsmith might be able to go after some other people based on what they tell him.
And Rollo, we're expecting him to be sentenced in October. What kind of legal situation is he facing at this point?
I think they were saying something like 2 years could be. And so my understanding is once you are over a year for federal, then you can get probation. You can get, good time served, so they could take some off. But he's looking at, I thought with Sweeney it was like a year, and Stanger was, I don't remember.
He could face more than 2 years.
Okay. And we've been following this over the weeks and months, and just remind us what Steve Stenger's legal situation is at this point.
He's pled guilty too. Yeah, all three.
Yeah, they have. None of them have been sentenced yet, as far as I.
So I think it's all in the fall.
So stay tuned.
Stay tuned. Yeah, indeed, and these are developments we keep following, and let's take a moment to just check back in quickly with St. Louis Circuit Attorney Kim Gardner, who we mentioned earlier, and we just have a few moments, but we do want to mention that the situation with Eric Greitens, former governor, she has admitted that she did the right thing when she charged then Governor Eric Greitens with a felony last year, but this comes after the person she hired to investigate Greitens, a former FBI agent named William Tisby, was indicted by a grand jury for several felonies, including perjury, evidence tampering. He has pleaded not guilty and is fighting the charges. My one question is, with all these kinds of stories circling around, does it get hard for that office to just keep doing its job?
I mean, I don't know from the inside, but I have to imagine that it's very hard. Kim Gardner's defended herself. She was not charged, but I believe the indictment said that she knew that her investigator, the former FBI agent William Tisby, she knew that he had taken notes while interviewing the victim of the nude photograph that the governor allegedly took,
which was never produced.
Which was never produced, right? But that she knew Tisby had taken the notes, and that maybe she'd even told Tisby to claim he hadn't taken the notes and not to turn over the information. So she's not charged, but she was sort of implicated.
The political team in our newsroom does continue to follow that, and we'll keep checking in on that. But we wanted to mention that. But we are running out of time here. So I do want to thank my guests for joining me today. Bill Freivogel, professor for the School of Journalism at Southern Illinois University, Carbondale. Mark Smith, associate vice chancellor and dean for career services at Washington University. All these academic types like to come in and talk.
We bring really big titles with us when we do.
Long titles. And Jacqueline Cutting-Bowder, managing attorney for civil rights and systemic litigation at Arch City Defenders. Thank you so much.
Thank you for having us.
Yeah, thanks.
This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.